You ready? You all ready? All right, it's right at 9 o'clock. We'll go ahead and take open announcements on the 9 o'clock docket. Just a few housekeeping notes. I don't see anyone on Zoom, so there's no one to talk to there yet. If you're in the courtroom, if you want to wear a mask, wear a mask. If you don't want to wear a mask, don't wear a mask. I'm not going to make your personal health decision for you, but I'm not wearing a mask. All right, and with that, we'll go ahead and take open announcements. Ms. Moore. Come on up, Mr. McDade. This is cause number CR 21-0122-392, the state of Texas versus Matthew McDade, and that is set for discovery status.
I did receive a copy of the offensive court live results, and I got a video yesterday.
Okay, anything else that you're expecting?
No.
Anything outstanding? All right, then, Mr. McDade, and I need to see the docket sheet. Court deems discovery status is held. Your next court date is July the 7th at 9 a.m. Thank you. And that is for pretrial. However, I'm going to order you to take a drug test today, just like you did the last time. You'll go take the test. Don't go anywhere. When you get done, come back in the courtroom. We'll go over the results together. Thank you, sir.
CPS is next door, so if I could.
We'll holler if we need you.
The other one I have is
Kevin Reed. Kevin Reed. So Kevin Reed. All right, it's cause number CR 18-0089-392, the state of Texas versus Kevin Reed. Was there Kevin Reed in the courtroom? I see no one. I hear no answer. There's no one on Zoom other than the court staff. The time is now 9:04. The docket was set for 9 a.m. Mr. Reed is not in the lobby. The court will entertain a motion. Granted, a capious issue, he'll be held with no bond. And I'm here all day if you find him.
I don't believe he has a bond, Your Honor. He
would have had one set on indictment, wouldn't he?
Well, I don't know. He went to Carroll State Hospital. His hold was released for him to go. And then when he was released from Carroll State Hospital, we never heard from him again.
The VA. Well, I'm going to leave the capious on him. When we find him, we'll figure out what to do with him.
Maybe,
Yes, ma'am. Mr. Schmidt.
Hey, Your Honor, Micah Thompson.
Micah Thompson. Come on up, Mr. Thompson. This is cause number CR 21-0028-392, the state of Texas versus Micah Thompson, set for discovery status.
Judge, we've received what I believe to be all discovery and discs.
All right, then, Mr. Thompson, the court deems discovery status is held. Your next court date is July the 7th at 9 a.m. for pretrial. However, based on the nature of your charge, I'm going to order you to take a drug test today. You'll go with probation, take the test. When you get done, come back in the courtroom and we'll go over the results together. Okay, sir? Thank you. We'll see you here in just a little while.
Stokes is my only one, I believe. I hope.
Oh, no, yeah, you're right. Jeffrey Stokes.
I just know the last night. Stokes.
This is cause number CR 21-0095-392, the state of Texas versus Jeffrey Stokes, set for discovery status.
Judge, and I have not addressed this with Mr. Strong. I apologize. Because I noticed something in the report and I went to watch the video last night and saw that it was actually just a CD of photos. And so then I looked closer at the report and noted that the officer said on June 3rd, this case was prepared and filed with the Henderson County District Attorney's Office. No Coban video is available at this time due to the Coban machine not working properly. There's a search issue that I wanted to watch. And so I don't know what that means. I don't know if it means there's no video or it wasn't able to copy.
It's at this time,
That's what, so, and I have not, this is the first I've raised it with the DA. So I just asked that maybe they make inquiry with the officer.
So here's what I'm gonna do. I'm gonna reset discovery status then. If you want me to do it that way, or you just want me to
Please.
keep, okay.
So that,
Then what I'm gonna do, Mr. Stokes, if that's all right with you, you're the one out on bond, is I'm gonna reset your discovery status to July the 7th, so your attorney can inquire and the state can figure out whether or not there is a video. Okay, and so we'll do that. You'll get a reset notice for July 7th, 9 a.m. for discovery status. However, based upon the nature of your charge, I'm ordering you to take a drug test today. You'll go with probation, take the test. When you get done, come back in the courtroom and we will go over the results together. Thank you, sir. We'll see you here in a little while.
Judge, I'll just step back with their drug test results.
Yes, sir. Screen.
Lockhart on page 3, Judge.
Carol Lockhart.
She down here, she lived Wise County, just found out a few minutes ago.
Wise County Jail.
Her mother let me know late yesterday as well.
On ARC warrant or on something else?
It looks like it's a new.
I guess there's not a warrant on that.
Right.
All right, well then we'll reset her discovery status to July 7th at 9 a.m. If the state will prepare a bench warrant, then I'll sign it.
Randy Earwood, right?
Randy Earwood. Come on up, sir. It's cause number CR 21-0082-392, the state of Texas versus Randy Earwood, set for discovery status. Where are we at?
Judge, as far as I can tell, we have all the discovery in this case.
You don't need the drug cases that are out of jail. I'm just trying to see whether or not they've taken a drug test previously. All right, then, Mr. Earwood, the court deems discovery status is held. Your next court date is July the 7th at 9 a.m. for pretrial. So we'll see you back on that date.
Thank you.
Yes, sir.
Judge, my last one, we're gonna have a plea. I just gotta get signed
Gotcha.
up. Thank you, sir.
Yes, sir.
Morning, Your Honor.
Morning.
I apologize, I do not know the page number on the docket. I'm here for Jamie Davis.
It's okay, we'll find it.
My name is Hicks.
Is it Jamie Davis?
Yes, Your Honor.
Okay. Oh, I see you right there. Jamie Davis. This is cause number CR 21-0123-392, the state of Texas versus Jamie Davis, set for discovery status. And Mr. Hicks, it's just a hearing that I hold before pretrial to make sure you have all your discovery.
I believe that I do. I've received and reviewed written discovery, just got the videos today on disc, so haven't had a chance to review them, but I
Sure.
don't right now anticipate any problem, Judge.
Okay, in state, is there anything outstanding you know of?
No, Your Honor, we have offers out.
And I will need to see the docket sheet on this one. All right,
Do I supply this to anybody or?
what do you got there?
Oh, this is a form. It's the receipt, I guess, my receipt for the signature.
That's ours. I can take that.
All right.
Thank you.
All right, then, Ms. Davis, court deems discovery status is held. Your next court date is July the 7th at 9 a.m. for pretrial. And however, based upon the nature of your charge, I'm ordering you to take a drug test today. You're going to go with probation, take the test. When you get done, come back in the courtroom and we'll go over the results together.
Dismiss, Your Honor?
I'm sorry.
Maybe excuse.
Yes, sir. Mr. Head.
All right, Trevor Newsom. Page 3.
Has a couple of cases. That's a runner.
Trevor Noose. Come on up, sir. How'd you get one in between it on the docket? All right, this is cause number CR 21, or cause number CR 21-0132. And then CR 21-0129, 130, and 131-392, all styled the state of Texas versus Trevor Newsom, and all set for discovery status. Mr. Head.
Your Honor, we have received discovery. To my knowledge, there's nothing outstanding at this time.
State, anything outstanding that you know
No,
of?
Your
All
Honor.
right. And Mr. Newsom, then the court deems discovery status is held. Your next court date is July the 7th at 9 a.m. for pretrial. So we'll see you back on that date. All righty. As soon as you receive your reset notice, you're free to go. No, on that other copy, yeah. I see it.
Then, Your Honor, I had a motion for early discharge on Robin Wallace at the top of page 5. If the state's ready. on that.
Is the state opposed?
As long as probation's on, we are.
All right, it's cause number CR 19-0930-392, the state of Texas versus Robin Wallace, and set today on a motion for early discharge. Mr. Head.
Your Honor, Ms. Wallace has been on for a little over a fourth of the term of the probation. It's a misdemeanor. She's complied with probation and is continuing to comply with probation. I think the only thing that's outstanding is some community service. She's had quite a bit of health issues that she has documented with the probation department. We'd prefer not to put those on Zoom or in the public sphere, but if the court has some question about those,
You
We
can
can
tell
meet
them
in
it's on his
chambers.
probation. Okay, she owes what?
$50 for probation. That's it.
And she's done? She got the $50?
I'm sure she does.
I
Your
can't
Honor.
understand. Uh-huh.
Yes, sir.
Okay. All right, well then, what is that? What is that? I hardly ever get these. Is there an order in here?
Your Honor, there should be. Let's just get that taken care of since court's over.
All right, well then, the court finds that the defendant has completed more than 1/4 of the probation, of the deferred adjudication probation, that when she pays $50 today, all fines and fees are paid, and the court waives the rest of the community service hours due to medical issues with the defendant, and I will grant it this I think it's the second day of June, 2021. All
Thank you, Your Honor.
right, good luck to you, man. Make sure you get that $50 paid. Make or break probation's budget, I guess.
And Your Honor, the only other matter I had on top of page 4 was another motion for early discharge on Stephanie Michelle, but she called late yesterday and got exposed to someone with COVID and was waiting for testing. So
Okay.
I suggested that we just reset that
Sure.
with court's permission.
You got a date, Kevin? July 6th, 1:30.
Yes, sir.
All right.
I'll advise her.
Yes,
Thank
sir.
you, Your Honor.
Mr. Stevens. Yes, sir. Appreciate you.
Your Honor, page 7, bottom of 7, Zachary Skursky, standing in for Bill Stevens.
Zachary Skursky. Cause number CR 21-0119-392, the state of Texas versus Zachary Skursky, set for discovery status today. Is there a Zachary Skursky in the courtroom? I see no one. I hear no answer. There's not a Zachary Skursky appearing via Zoom. Time, he's not in the lobby. The time is 9:17. Docket was for 9 a.m. The court will entertain a motion.
State would request bond forfeiture.
Granted, KP so issue, he'll be held with no bond.
Thank you, Judge. Maybe excuse.
Yes, sir. All right, I'm going to go through the docket. If you hear your name called, I just need to know that you're here. I don't need you to come up until your attorney's ready. Paula Jean Kikua? All righty. Have you talked to your attorney? When's the last time you talked to her? I can't hear you unless you stand up. You're in a courtroom. Thank you. Okay. Well, I think she's supposed to be appearing via Zoom. We'll find her. So have a seat, ma'am. Actually, can I see her docket sheet? Yeah, if they're out of jail and was charged with PCS or something that has to do with drugs. Let's see. I need a drug test on Miss Kikua. Y'all need to keep it down, please. On Miss Kikua. What's that? Yeah, KKOA. That's what I said, right? I'll get it. So if y'all get me one of those, I'll sign it. Ma'am, I'm going to order you to take a drug test, just like you did last time. When you get done, come back in the courtroom, and when your attorney's here, we'll go over it. Next, Peggy Grider. Are you ready? All right, y'all come on up. And then I'll need to see Peggy Grider. Paula Jean. There's a drug test on her. All right, this is cause number CR 21-0115-392, the state of Texas versus Peggy Grider, set for discovery status. Ms. Cummings?
I think we've received everything. I think the state and I are currently working on a plea agreement, and maybe if we could get it reset one more time, we can plea out next month.
Well, we'll set it for pretrial, and I didn't ask those first couple. Is there a plea offer?
Yes.
What's the offer?
It's 3 years deferred.
Okay. All right. Well, then, Ms. Grider, the court deems discovery status is held. Your next court date is July the 7th at 9 a.m. for pretrial. And can I see the docket sheet? I don't know whether I gave her a drug test or not. Well, it doesn't say. Ma'am, I'm going to order you to take a drug test today, though. You're going to take it. When you get done, come back in the courtroom and we'll go over the results together.
You just want to go over the probation department.
They'll take her over there. All right, continuing on, is there Robert Stewart here?
He's present, Your Honor. It's going to be a plea.
Okay. Jerome White,
On his way.
cause number CR 21-0154-392, the state of Texas versus Jerome White. Also, CR 21-0405 and 0406.
He said texting me. He said he'd be here in 10 minutes. His ride had a flat tire.
I just want to do it now because if he doesn't show up, I don't want to wait until noon to call his name. All right, is there a Jerome White in the courtroom? I see no one. I hear no answer. Ms. Fallhaber says he's on his way. He's not appearing via Zoom. The docket was set for 9 a.m. It's now 9:20. The court will entertain a motion. All right, the court conditionally grants the forfeiture. If he doesn't show up, he'll be held without bail and a case will issue. But if he shows up, we'll deal with it then. No way, we don't have to do it later. I've heard that story. I'm on my way many times and we wait and wait and wait. Christy Riggle,
She's in custody. That'll be a plea as well.
gotcha. Troy Aldridge,
Mr. Aldridge is here.
gotcha. Did I already do Robin Wallace? Is that who I just did? Okay. Casey Albers. Okay, Mr. Harrington should be here. Have you seen him? Have you talked to him? Okay, we got two courts going right now. He is in the building. Mr. Jimenez, see you. Mr. Harrington again, across the street or across the hall. Michelle Ortiz, he's in Dallas County.
Yeah, they rejected our bench warrant. They're not gonna release him until his case.
The court rejected it or the sheriff did? Oh, okay.
So, we can push it 6 months and then see where he's at.
Do you have a setting like in August or September? Let's do August 4th, 9 o'clock. So on cause number CR 21-0126-392, the state of Texas versus Michelle Ortiz. Apparently he's in Dallas County Jail and they're not releasing him. And so if the state will.
Do you want that one?
If the state will draft a bench warrant, I'll sign one for August 4th at 9 a.m. Robert Stepp. Gotcha. And then finally, Clayton Charlton. Clayton Charlton.
He's here in Minnesota.
Miss Altier, I see you. I'll get to you in a minute. Okay. Who did we, it's Marcel out there?
Told her to appoint an attorney. He qualifies. What last month he was here, he wanted to hire Justin. Do that, so I told her to go ahead and try.
Let's see the docket sheet on Charlton. Okay, there you go. I'm going to order her to take or him to take a drug test, not Miss Fallhaber, her client, Clayton Charlton. Take a drug test. Well, maybe somebody left some pee in there. Apparently that happens. Is that Mr. Charlton? Mr. Charlton, I'm ordering you to take a drug test. You're going to go with probation, take the test. When you get done, come back in the courtroom. Miss Fallhaber is your lawyer and she'll talk to you, but let's get that drug test going. All right, Miss Altier was here. Now she's dropped off. Well. Do we have any results back? What are y'all cross training? We gotta read my mind. Yeah, it takes a while. Now, only on people that have PCS or a charge that may involve drugs. I just want to see, have I tested them before? And then kind of see whether they're negative or positive. So like people in jail, I typically don't need to see unless I ask for it. Who? Oh, Mr. White. Come on up. All right, these are cause numbers CR 21-0154 and CR 392 and CR 21-0405 and 0406-392. Let's go ahead and arraign him on the 05 and the 06 cases.
Now comes Jerome White, represents the court that his name is spelled correctly, waives formal reading of the indictment, enters his pleas of not guilty for purposes of arraignment.
All right, Mr. White, then the court deems, court notes your pleas of not guilty for purposes of arraignment. You're going to receive 2 new court dates on each of those cases. That is for August the 4th at 9 a.m. for discovery status. And then again on September the 1st at 9 a.m. for pretrial. So now let's move on to the discovery status case. Basically, what I'm going to do is I'm just going to set that for August 4th at 9 a.m. I'm just going to reset discovery status. That way they'll all run together.
Thank you.
All right, and Mr. White, I don't need any answers, but there's 2 things you don't want to be late for: your wedding and felony court. You understand? So I appreciate that you made it. If you had a flat tire, I'm going to mark on the docket sheet that you were late. I hope it doesn't happen again next time. All right. However, based upon the nature of your new charges, I am ordering you to take a drug test today. You're going to go with probation, take the test. When you get done, don't leave. Come back in the courtroom and we will go over the results together. And the court is withdrawing or recalling the bond forfeiture. All right, so let's go with probation, take that test, sir. Miss Altieri, you got me? Miss Altieri? You're muted.
I'm here, Your Honor.
I sent Miss Paula Jean to take a drug test, and I don't
Yes.
see that she's back yet. I figured I'd just get it knocked out. So as soon as she gets back, I'll bring you back in.
Okay, I'll be waiting. Thank you.
All right, anybody else ready on anything?
Maybe result from Mr. Stokes, but I'm not sure.
Yeah. You're still muted. Do we got any results? All right. Yes, ma'am. All right. Matthew McDade. You passed your test. You're free to go, sir. We'll see you in July. Jeffrey Stokes. You passed your test, sir. You're free to go. We'll see you in July. Jamie Davis, come on up. All right, this is back on the record in cause number CR 21-0123-392, the state of Texas versus Jamie Davis. Ms. Davis, based upon the nature of her charge and the fact that she's out on bond, was ordered to take a drug test. She took that test. Apparently, she's tested positive for methamphetamine and benzodiazepines, and allegedly admitted to swallowing and smoking Xanax and meth on May the 30th. And so, Miss Davis, everybody gets their 1 free shot in this court. So what I'm going to do is I'm going to place conditions of bond on you. No alcohol, no illegal drugs, no drugs not prescribed, and no THC or marijuana. I know it's legal in a lot of states, but it's not. It's still against federal law and it's against Texas law. How long, I don't know. But none of that either. So you're going to receive written bond conditions. And once you receive those with my signature, you're free to go. When you come back in July, I'm going to test you again. And if you test positive, I can't promise you'll go out that door. You may go out that one, which leads to the jail in a roundabout way. If you need help, ask. There's lots of help out there.
Your Honor, man, Ms. Davis lives in Dallas County. I wonder if there are going to be reporting type of requirements.
No, they're not reporting. It's just me ordering her not to do those things.
All right.
No, sir, no reporting.
Thank you.
Yes, sir. And once you receive my signed copy of those, you're free to go. Yes, ma'am. All right, anything else ready? Mr. Green, anything? All right, well, going once, going twice. All right, we'll take a recess. Y'all let me know when we have something ready. Ms. Altieri, are you with us?
Yes, I am, Your Honor.
Her client back? Oh, I thought we were gonna take care of it. Did Miss Kikuhua?
She's not back yet.
She's not back. Sorry, she's not back yet, Miss Altieri.
Okay, I'll wait.
Yes, ma'am.
Thank you.
All right, this is cause number CR 20-0238-392, the state of Texas versus Troy Allen Aldridge. And that is set for plea today. Is the state ready? Mr. Aldridge, we're just waiting on the state to get their files. Stand there for a minute. All right, and on behalf of Mr. Aldridge,
We're ready, Your Honor.
all right, sir, is your name Troy Allen Aldridge? And are you the same person that was originally indicted by Henderson County Grand Jury for the third-degree felony offense of assault family violence? I get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. Now, you have to speak a little louder so we can hear you. You can lower your hand. All right. Mr. Aldridge, can you read and write the English language?
Yes.
Are you a U.S. citizen?
Yes.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes.
And Mr. Aldridge, have you ever been treated for any mental health or emotional issues?
No.
Do you understand what's going on in here today?
Yes,
And Mr. Green, do you believe your client is competent?
I do, Your Honor.
The court finds he is competent. Mr. Aldridge, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a third-degree felony. The third-degree felony carries a punishment range of not less than 2 years nor more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
However, it's my understanding that you have this deal worked out with the state whereby they would recommend that this be convicted and punished as a Class A misdemeanor. A Class A misdemeanor carries a punishment range of up to 1 year in the county jail and a fine not to exceed $4,000. Do you understand that range of punishment? And the plea bargain?
We're recommending 324 days confinement with credit for 324 days and a $305 cost.
And attorney's fees?
Yes.
Is the complaining witness on board with the plea bargain?
That is right.
Okay. Is that your understanding of the plea bargain, Mr. Aldridge? Is that your understanding, Mr. Green?
Yes, Your Honor.
Well, Mr. Aldridge, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Green? And did you sign it? Do you have any questions about it? The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document with Mr. Green? Is that your signature there on the second page? Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with Mr. Green? Well, if you read and went over these with him, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? You want to enter into this plea bargain? Then I'll ask you, sir, how do you plead to the lesser included offense of assault family violence of that which is charged in the indictment, a Class A misdemeanor? Are you guilty or not guilty? And are you pleading guilty because you are guilty and for no other reason? I hear the evidence.
The state has 2 articles of evidence. The first is the instant or offense report from the day in question.
No objection.
Admitted,
The second is the initial case submittal inventory report.
No objection.
admitted.
The state was closed.
Rest closed.
All right, Mr. Aldridge, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense, that Class A misdemeanor assault family violence. The court will follow the plea bargain, sentences you to 324 days in the county jail with credit for 324 days and orders you to pay your attorney's fees and court costs. And Mr. Aldridge, did you get an opportunity to review the judgment of conviction in your case? Is your name, the charge, and the time credit correct? All right, sir, you need to see the bailiff before you go to be printed. Good luck to you.
Your Honor, that's all my business.
Yes, sir.
Maybe excuse to the Saturday.
See you then. Mr. Schmidt. That's Peggy Grice. Thank you. All right, this is back on the record in cause number CR 21 -0029 -392, the state of Texas versus Micah Thompson. Based upon the nature of Mr. Thompson's charge, he was ordered to take a drug test. He took that test and it apparently is positive for methamphetamine and apparently admitted to consuming meth on 5/28. And so, Mr. Thompson, you are on bond. I'm going to place conditions of bond on you. No alcohol, no drugs not prescribed, no illegal drugs, and no marijuana or THC in any form. And so you always get your 1 free shot with me. You are on bond. And so when you come back in July, I'm going to test you again. If you test positive in July, I can't promise you that you'll go out the front doors. You may go out the side doors. You understand that? And if you need help, ask. There's lots of help out there. I'd rather have you in help than in jail. All right. And as soon as you receive my signed copy of your bond conditions, you're free to go, but just have a seat and wait on those. Thank you, sir.
Once we get those now.
Yes, sir. Appreciate you. Mr. Harrington. Casey Albers. Ms. Albers, how do I know you? Football? It's cause number CR 21-0127-392, the state of Texas versus Casey Albers, set today for discovery status. Mr. Harrington. All right, and is there an offer?
Yes, Your Honor, we have offered 15 months TDC probated for 24 for the 5 substance abuse violation.
You mean, okay. All right, well then, Ms. Alvarez, court then deems discovery status is held. However, I'm going to order you to take a drug test today. You'll go take the test. When you get done, come back in the courtroom. We'll go over the results together. And your next court date will be July the 7th at 9 a.m. for pretrial, but don't go till we talk about your drug test results. Sir. Sir. Rudy Jimenez. All right, these are cause numbers CR 21-0096 and 0097-392, both styled the state of Texas versus Rudy. Is it Jimenez or Jimenez? Jimenez. Rudy Jimenez, set for discovery status, Mr. Harrington.
You're not going to find, I believe, on discovery, this point is file. I have no issue at this point.
Everything.
Everything's been provided. There's no current.
Okay. All right, then, Mr. Jimenez, court then deems discovery status is held. Your next court date is July the 7th at 9 a.m. for pretrial. So we'll see you then. Sir. Ms. Cummings. Got Peggy Grider's results, right? Ms. Grider, come on up. So it says swallow, then it says deny. What does that mean? So you don't know? Oh, okay. All right, this is back on the record in cause number CR 21-0115-392, the state of Texas versus Peggy Grider. And Ms. Grider, based upon the nature of her charge, was ordered to take a drug test. Can I see the docket sheet? I can't remember whether it's her first one or not. I see the docket sheet. Okay. Ms. Grider was ordered to take the test. She took the test and apparently is positive for methamphetamine and amphetamine and admitted apparently to swallowing methamphetamine back on May the 22nd. And so, Ms. Grider, you don't look like you're in physical shape to be doing this kind of business. Not any good for you if you are doing it. And so I'm going to place conditions of bond on you. Oh, she does?
Yeah.
Has she tested positive before?
There's no UA results before.
Okay.
Nothing in the note.
Yeah, I didn't see, I didn't,
I think she was just arraigned last month or month before.
well, normally she'd get drug tested, but for some reason she wasn't,
I
so.
think she had COVID. She appeared to be as in.
Okay, well, Ms. Grider, then, you already had conditions of bond. We'll get you a copy of that, but everybody gets their one free shot with me. If you need help, get it. And especially if you had COVID and the physical condition that you appear to be, if you are using methamphetamine, that's not good for you. It's not good for healthy people. And so if you need help, get it, because if you come back in next time and test positive, you may go out that door, not that one, okay? All right, we'll see you in July. Once you receive a copy of those conditions of bond, you're free to go, but wait till you receive a copy.
Thank you.
Yes, sir. Mr. Stevens.
Sorry, Mr. Skirsky showed up. Zachary Skirsky.
Trying to find.
Sorry, second to last page.
He wasn't here before. Did I do a bond forfeiture on him?
Yes, sir.
All right, this is CR 21-0119-392, the state of Texas versus Zachary Skursky, and Mr. Skursky wasn't here. Mr. Stevens, do we have a?
Your Honor, I just came from across the hall. I know it's not an excuse for him, but I did try to get over here a little early. I think it was a little after 9 to have it heard so I could go back to CPS court. He wasn't here at that time. His bondsman informed me that she had received a call that he was on his way. Had I known that, I would have held off calling the case, obviously.
I
But
see the docket sheet. I understand. This happened with him before, back in April 8th, with Bill. His name was called 3 times, no answer. He arrived late. He was ordered to take a drug test. He's positive for meth and amphetamine, admitted to snorting it on the 4th. And today he shows up late. So let's go ahead and hold discovery status. So I'm sorry, what was that?
he said he got pulled over on the way over here by law enforcement, which I guess delayed him from being here on time.
I'm sorry about that, Your Honor.
They give you a ticket.
Who was it that pulled him over? Who was it pulled you over?
I'm not sure it's a cop in Eustis.
The short guy?
Yes,
The short guy?
yes, sir.
Did you tell him you were on your way to court
Yes, sir.
and he let you go?
Yes, sir.
What did he pull you over for?
Speed.
Don't speed through Eustis. Or Payne Springs. Or Bald Springs. The Tool, or Kearns, Brownsboro. Just don't speed. All right, I'm gonna recall the bond forfeiture. There's 2 things you don't want to be late for. And this is your second one. Your own wedding and felony court, but I do appreciate the fact that you were trying to get you here, but if you leave earlier, you don't have to speed. Any discovery issues?
We request the standard order we signed.
No objection.
No, that's pretrial. This is set for discovery
And I
status.
believe Mr. Stevens has received all the discovery.
Okay. All right, well, then the court deems discovery status is held. Mr. Skursky, your next court date is July the 7th at 9 a.m. for pretrial. What time is it?
9 a.m.
There you go. What time should you be here?
8:45.
There you go. However, I am going to order you to take a drug test today, so you'll go take the test. You know the drill. When you get done, come back in the courtroom. We'll go over the results together. Don't go anywhere. Or Caney City, coming over the bridge.
Thank you, Your Honor.
Yes, sir. Right. Still school's on. You got summer school. You got workouts. You got.
Your Honor, I'll be next door.
Yes, sir. We'll call you if we need you. It is. How about Clayton Charlton? Did he finish his drug test? Have you talked? That was Miss. Have you talked with Miss Fallhaber yet? Oh, there you are. I didn't even see you standing there. Are you ready for him? Are we ready for discovery status? Okay, come on up, Mr. Charlton. All right, let me see that. This is cause number CR 21-0041-392, the state of Texas versus Clayton Charlton. And that is set for discovery status. Where are we at?
I just got appointed in court today, so I don't have anything.
Gotcha. That's right. So we'll reset discovery status for July 7th at 9 a.m. However, Mr. Charlton, back on April the 8th, showed up for arraignment. Well, let's go all the way back. On March the 4th, he didn't appear.
I was having issues on the internet.
Right, we set it today on to April the 8th. On April the 8th, ordered to UA, he was positive for meth, amphetamine, benzodiazepines, and THC. He admitted to Xanax, meth, and marijuana. We reset it for May the 6th at 9 a.m. to hire Justin Weiner, and I placed conditions of bond on him and served it in court. I don't see that we had a May 6th setting. However, he's here today, June 2nd. The court ordered a UA, and apparently Mr. Charlton has tested positive for methamphetamine and amphetamine again. And so what is his bond? Can I see the indictment? His bond's currently $8,500 surety bond. Court finds his bond insufficient, and bond is now $17,000 surety bond. And so if you do bond out, Mr. Charlton, you need to get help. That's the second time in a row, and you're on bond. There's lots of help out there. You just got to ask. If I were to, because you're set in July, and if you were to be in a drug rehab, I'd excuse you from that, because I'd rather you'd be there than in jail. All right, well, the meetings aren't working, so you need to have a seat in the jury box. Bond insufficient, set at 17,000 surety. Is there an offer?
Yes, there is. Your
Okay,
Honor.
what is it?
At 18 months TDC, probated for 36 months.
I
fine.
mean, state jail?
Yes.
And Your Honor, of course, I haven't seen the evidence, but because it is a mandatory probation case, and I don't think he's gonna find out, I think we're gonna take that, and so I'm gonna request a plea setting for sooner.
This afternoon?
I'm gonna have to have time to get the evidence.
Sure, it's an offense report, and if it's a traffic stop, it's a DVD. But I understand. I don't.
I mean, and I'm happy to do it. I'm sure my client would be delighted.
I'm sure he would. I'm just trying, well, put it this way. I'm sure the state can get you a copy of that pretty quick. And I'll be here at 1:30.
Yeah, I mean, I think it's possible. It's possible on my end, it's possible on your end. Okay, and like I said.
You want me to bring him back at 1:30?
Yes, please.
Okay.
I know he would love that.
That'd be great.
Okay,
We'll go over, feed him lunch, and bring him back.
okay. I guess I'm working through lunch. Is it already copied? And then I have a couple of plates that probably are-
Mr. Charlton, I'm going to bring you back at 1:30 today. So your attorney's going to get your discovery packet, and we're going to bring you back at 1:30, and you'll have a chance to talk, but you're still going to have to go to jail. They'll feed you lunch, book you in, and we'll bring you back. What's on the menu today?
Better than Dallas, they do bologna.
Well, they do wheat and white. You get one of each in Dallas County. That way, if you don't like wheat, you can trade with your buddy. And then
Yep. Or in Corsicana, the jail, they do the dehydrated food. They just add water and it turns back into food.
been there, done that. The old MREs. Righty. And so who else we got? Do we have Miss Paula Jean? Come on up, ma'am. Miss Altier, I think we're good to go now.
Very good. Thank you, Your Honor.
All right, this is cause number CR 21-0085-392, the state of Texas versus Paula Jean Kikahoa. Kikaoha. All right, set for discovery status, Mr. Strong.
Everything's been provided to Ms. Altier. There is a current offer of a 3-year deferred probation.
And who's that offer on?
Ms. Paulson.
Oh, you have to go see if you could, the more we say it, we can practice at it. Miss Altier, do you have all the discovery?
I do, Your Honor, and we do also have a copy of the offer.
Do we have a lab report back from what we?
The 21st and came back on negative.
Okay. All right. Well, ma'am, we've drug tested you back in April. You were positive for amphetamine, but you advised you had surgery. We sent that off for confirmation and it came back negative. However, today you have tested positive for methamphetamine and amphetamine and have admitted to smoking meth on 5/28. So I guess I'll give you the same free shot that I give everybody else since your first one wasn't confirmed, even though you were on notice. And so here's what I'm going to do. I'm going to reset your case for July 7th at 9 a.m. for pretrial, or set it for pretrial on July 7th at 9 a.m. And I'm going to drug test you again when you come in. If you test positive that time, then I can't promise you'll go out that door. You may go out that one, you understand? And so if you need help, ask. There's lots of help out there. Like I told this gentleman, I'd rather you be in some program getting help than in jail. And I know everybody else would too. Ms. Altier, you got anything?
No, Your Honor.
Okay, all right.
We
we'll see
would
you in
rest
July.
and close. Okay.
All right.
May I be excused too, Your Honor?
Yes, ma'am. Thank you.
Thank you.
Yeah.
Yeah, you got it. Just make sure she has a copy of it. All right, we ready on anything else? the one they used. Let's see, who do we got? Robert Stewart. All right, this is cause number CR 21-0078-392, State of Texas versus Robert Stewart. And that is set for discovery status today. However, a plea has been presented to the court. It's a state ready.
Yes, Your Honor.
And on behalf of Mr. Stewart,
Ready, Your Honor.
sir, is your name Robert Glenn Stewart?
Yes, sir.
And are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense of possession of a controlled substance?
Yes, sir.
I can get you to raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. All right, yeah, wait for me to finish. Go ahead and lower your hand. All right. Mr. Stewart, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
Mr. Stewart, have you ever been treated for any mental health or emotional issues?
Yes, sir.
Do you understand what's going on in here?
Yes, sir.
Ms. Paulhaber, do you believe your client is competent?
I do.
The court finds he is. Mr. Stewart, I know that you've already been arraigned on this case. However, would you like the prosecutor to read the indictment against you out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand the range of punishment
Yes, sir.
in the plea bargain?
We are requesting 18 months probated for 48 months, right, for 3 days served. Standard terms and conditions of probation as well as restitution.
And then $2,500 fine, attorney's fees, court costs, and lab fee.
Yes.
Right, is that your understanding of the plea bargain, Mr. Stewart?
Yes, sir.
Is that your understanding, Ms. Fallhaber?
It is.
All right, well, Mr. Stewart, a few minutes ago, you told me you could read and write the English language. I'm going to go over 2 documents with you. The first is the agreed plea recommendation. Did you read and go over both pages of that, front and back, with Ms. Fallhaber?
Yes, sir.
And did you sign them?
Yes, sir.
You have any questions about it?
Yes, sir.
The next document I'm going to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea.
Yes,
Did you read and go over both of those pages?
Yes, sir.
Did you sign that second page there?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Ms. Fallhaber?
No, sir.
Well, if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case?
No, sir.
Do you want to waive your right to a trial and enter into this plea bargain with the state?
Yes, sir.
Then I'll ask you, sir, how do you plead to that state jail felony offense as alleged in the indictment? Guilty or not guilty?
Yes, sir.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I'll hear the evidence.
Your Honor, I have 3 things to learn evidence. The first is an incident report from the day in question.
Any objection?
No, Your Honor.
Admitted.
The second is a submittal inventory report.
No objection.
Admitted.
And finally, the rollout report.
Admitted. Anything else from the state?
No, Your Honor, rest of the.
Ms. Fallhaber?
Resting place.
All right, Mr. Stewart, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that state jail felony offense of possession of a controlled substance. The court will follow the plea bargain, sentences you to 18 months in a state jail felony facility. However, the court will probate that sentence, places you on community supervision for 48 months. You do have 3 days credit as to any sentence you may have to serve. and orders you to pay your fine, attorney's fees, court cost, and lab fee, and to abide by all the regular and special terms and conditions of community supervision. Mr. Stewart, have you ever been on probation before?
No, sir.
All right, well, there are lots of things you have to do and a few things you can't do on probation. You understand that?
Yes, sir.
And do you know what can happen to you if you violate even one term or condition of this?
Yes, sir.
What can happen?
Go to prison.
Go to state jail for up to 18 months. Is that right?
Yes, sir.
And do you know how state jail time is served?
No, sir.
It's typically served day for day. You understand that?
Yes,
You
sir.
get 18 months, you do 18 months, and you've only got 3 days credit.
Yes, sir.
All right, here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be held without bond, brought back before the court, and if at a hearing, the court found it were true that you violated even one term or condition, the court could revoke your probation and sentence you to 18 months in state jail. Do you understand that?
Yes, sir.
All right, so would you agree with me? It's extremely important that you abide by these.
Yes, sir.
All right, sir, and now that you have been finally convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult an attorney. All right, you need to see Mr. Halbert to your right, and then you need to meet with probation. Good luck to you, sir.
Thank you.
Miss Riggle, come on up. You've been waiting all morning. And Miss Riggle, before we get started, you can go ahead and pull that mask down. Yes, sir. Good luck to you. So we've got, she's doing 2, please. Yeah, give me a minute. Let me get my paperwork sorted out here. She ran out of here pretty quick, didn't she? Oh, okay. When I do 2 or more, I like to get everything signed before we start. Who was she here with? When I got 2 or more, I like to sign all the paperwork first. It's a lot easier. Goes smoother. All right, we're ready. All right, these are cause numbers CR 21-0063 and CR 21-0243-392, and both of these are styled State of Texas versus Christy Riggle, and both set for pleas. Is state ready? And on behalf of Ms. Riggle.
Ready.
All right, ma'am, is your name Christy Michelle Riggle?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury in this 0063 case for well, just for the felony offense of abandoning or endangering a child? You the same person? And you also the same person that was indicted by a Henderson County grand jury for the felony offense of manufacture delivery of a controlled substance. If I can get you to raise your right hand, please. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hands. Ms. Riggle, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? Ms. Riggle, have you ever been treated for any mental health or emotional issues?
Yes, sir.
Okay, and have you been diagnosed or treated for anything?
Yes, sir.
And what would those be?
Manic depression, bipolar, and severe anxiety.
And are you on medication for any of that?
Yes, sir.
And are you taking it as prescribed?
Yes, sir.
So the jail's giving it to you?
Yes, sir.
And do you understand what's going on in here today?
Yes, sir.
And Ms. Fallhaber, do you believe your client is competent?
I do, Your Honor.
Well, Ms. Riggle, even though you've told me that you have these diagnoses and you're on this medication, based upon your demeanor in court, your answers to my questions, and statements from your attorney, I have no reason to find that you're not competent, therefore I'm finding you competent. Ms. Riggle, I know that you've already been arraigned on each of these cases. However, would you like the prosecutor to read the indictments against you out loud here in the courtroom? But do you understand the charges?
Yes, sir.
Well, as indicted in this 243 case, that case is going as first degree felony. Is that correct?
First degree paragraph A enhances 15 to life imprisonment.
In case you're abandoning that enhanced paragraph. All right, so the underlying offense in paragraph B of that 243 indictment is a first degree felony. A first degree felony carries a punishment range of not less than 5 nor more than 99 years of life in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
And in this 0063 case, that underlying offense with enhancements is a third degree felony. A third degree felony carries a punishment range of not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
And the plea bargains in each of the causes?
Yes, Your Honor, in the manufactured delivery paragraph A, the states to abandon the enhancement paragraph. The agreement is for 10 years TDC plus attorney's fees for a cost of $180 in lab restitution. That's to run concurrent with the state jail felony endangering a child. That's concurrent at 5 years TDC.
Is that your understanding of each of the plea bargains, Ms. Riggle?
Yes, sir.
Is that your understanding, Ms. Fallhaber?
It is.
Ms. Riggle, a few minutes ago, you told me you could read and write the English language. I'm going to show you a couple documents here. There's going to be 2 from each of these causes. The first is the agreed plea recommendation. I'm showing you 2 because it's 1 for each case. Did you read and go over for each of these cases, both the front and back of that document?
Yes, sir.
And did you sign them?
Yes, sir.
Do you have any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Now, I'm showing you 1, but there's 1 for each case, and the only thing different is the cause number at the top. Did you read and go over that with Ms. Fallhaber for each case?
Yes, sir.
And did you sign the second page in each case?
Yes, sir.
Do you have any questions about it?
No, sir.
Do you have any questions about any of the documents you signed in any of these cases?
No, sir.
Well, if you read and went over these with Ms. Fallhaber, I know she explained to you that in each of these cases, you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in any of these cases?
No, sir.
Do you want to enter into both of these plea bargains?
Yes, sir.
Then I'll ask you, ma'am, in cause number CR 21-0243-392 to that first degree felony offense in paragraph A of that indictment, are you guilty or not guilty?
Mhm.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And now in CR 21-0063-392 to that abandoning or endangering a child felony offense as alleged in the indictment, a state jail felony, are you guilty or not guilty?
Yes, sir.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And is it true or not true? Was it a Brooks notice? Oh, no, it's on the second page. I see it. Is it true or not true, ma'am, that in January of 2015 in the 13th District Court of Navarro County, you were finally convicted of a state jail felony offense of theft of service? Is that true or not true? All right, and you're pleading true because it is true and for no other reason. Right, and then also, is it true or not true that in the 3rd District Court of Anderson County in March of 2016, you were finally convicted of the state jail felony offense of possession of a controlled substance? Is that true or not true? Are you pleading true to that because it is true and for no other reason? Right, and the court in 0243 grants the state's motion to abandon the enhancement paragraph. And the court will hear the evidence.
Thank you, Judge. The state offers in the evidence states 1, 2, and 3. 1 is the offense report. 2 is Morton discovery compliance, and 3 is the weapon.
No objection.
Admitted.
Nothing's further.
Rest in case.
I'm just looking at the lab weight. All right, well then, Ms. Riggle, and cause number CR 21-0243-392. Based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of paragraph A of that indictment, that first degree felony offense of manufacture, delivery of a controlled substance. The court having abandoned and the court having granted the abandonment of the enhancement paragraph, sentenced you to 10 years in the Texas Department of Criminal Justice, credit for 201 days as of today, and orders you to pay your attorney's fees, court costs, and lab fee. In this case, will run concurrent with CR 21-0063-392. In that case, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that abandoning and endangering a child. The court also finds, based upon your pleas are true and the evidence, both enhancement paragraphs true. The court follows the plea bargain, sentences you to 5 years in the Texas Department of Criminal Justice with credit for 201 days, and orders you to pay your court costs. In this case, will run concurrent with CR 21-0243-392. Now, before you go, Ms. Riggle, a couple more things to go over with you. Have you had an opportunity, or did you get an opportunity to review both of the judgments in your case, your cases?
Yes.
In each of those, was your name, the charge, and the time credit correct? All right, and finally, ma'am, now that you've been finally convicted of these felony offenses, you are now under Texas law ineligible to possess a firearm or ammunition. Those are legal terms. If you have any questions, consult with an attorney. And ma'am, you're now remanded back to the custody of the Henderson County Sheriff for transport to the appropriate authorities to serve out your sentence. Good luck to you, Ms. Riggle. You need to see Mr. Halbert before you go. Sir. Let me get your paper clips back to you.
My last client that I was waiting on is not in the building.
It's not in the building. Elvis has left the building.
Seems to be a common theme.
Hey, we had that happen when your client's going to get some water.
That's why he's joking with me.
Yes, sir. We'll see you at 1:30, sir. And who would that be?
Jerome White.
Yeah, he had a flat tire and got pulled over. All righty, let me call it. It's cause number CR 21-0154-392, the state of Texas versus Jerome White. And also CR 21-0405-392, styled the same way. Is Mr. White in the courtroom? There's no one but Ms. Fallhaber, the district attorney, the court, and the clerk staff. Is Mr. White appearing via Zoom? He is not. Mr. White was ordered to take a drug test. After showing up late for court, the court rescinded the bond forfeiture, ordered him to take a drug test and probation. Is he in the office?
No.
He is not in the building. And his name was called 3 times in the lobby. He did not answer. The court will entertain a motion.
Thank you, Judge. State request block.
granted a capious will issue, and his bond in each case will be $1 million. All right, let's do this. We on the record?
He's coming, he's talking to Brad.
Oh, okay. I didn't wear my robe because I thought we were gonna be real easy here. Coming up, Mr. Skirsky. All right, this is cause number CR 21-0119-392, state of Texas versus Zachary Curtis Skirsky. And let's see, Mr. Skirsky was sent off to take a drug test. He was late this morning. I sent him off to take a drug test. Appears as though he has tested positive for meth and is denied use. Looks like back on April the 8th, he tested positive for methamphetamine and amphetamine and was placed on conditions of bond. Just meth, what?
That means normally it's on his way out.
Here's what I'm gonna do, Mr. Skirsky, is I'm gonna send it off for confirmation. And to the lab, y'all keep it.
Yes, sir.
All right, because that's kind of, if you just test positive for meth and not meth and amphetamines, I'll give you the benefit of the doubt, send it off for confirmation. And I'll see you in July and we'll have them back and we'll go over them then. All right, don't speak through Eustis on your way back. We'll see you in July.
All right, thank you. May I be excused?
Yes, sir. Appreciate you. What are you reaching up here for?
Thank you.
Doesn't look like we have anybody on Zoom, do we? Nope. I guess everybody's ready. You ready? That's okay. All right, well, ladies and gentlemen, we'll go ahead and get started on the 1:30 docket. I think everybody in here has heard my message about masks. If you want to wear one, wear one. If you don't, then don't. It's up to you. I'm not going to make your personal health decision for you. So with that, we'll start off and call the 1:30 docket. Open announcements, Ms. Fallhaber.
Thank you, Your Honor. I've got Clayton Carlton on.
Mr. Charlton, come on up.
By the way, did not give his lunch.
You can get a lunch?
You're not complaining, huh?
We didn't feed them lunch over there, or they eat it early?
He was probably processing.
Yeah. That's all right. All right, we'll go ahead and call it. This call's number CR 21-0041-392, the state of Texas versus Clayton Lee Charlton. And this is just set earlier today for discovery status. And Mr. Charlton's bond was found insufficient due to a positive drug test. His attorney asked that he be brought over at 1:30 today because there was already an offer on the table. And now a plea has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Mr. Charlton,
Ready, Your Honor.
all right, sir, is your name Clayton Lee Charlton? You got to speak up just a little bit because I'm hard of hearing. All right, and are you the same person that was originally indicted by Henderson County Grand Jury for the state jail felony offense of possession of a controlled substance? I get you to raise your right hand as best you can, sir. You solemnly swear or affirm testimony you're about to give now at trial will be the truth, the whole truth, and nothing but the truth, so help you God. You can lower your hand. Mr. Charlton, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
Well, if it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. So you understand that. Mr. Charlton, have you ever been treated for any mental health or emotional issues?
No, sir.
You understand what's going on in here today?
Yes, sir.
Ms. Fallhaber, do you believe your client is competent?
I do, and I would waive 10 days preparation.
Okay, and then as a new attorney, a newly appointed attorney, and thank you for that. And the state had any objection to waiving the 10 days?
No, Your Honor.
All right, well, then the court grants the waiver of 10 days. Mr. Charlton, the court then finds that you are competent and finds that you've waived your 10 days for your attorney's. Your attorney gets 10 days when she's appointed to do anything, but you want to go forward today? Is that correct?
Yes.
All right. Well, Mr. Charlton, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom? If you understand the charge?
Yes, sir.
Well, as indicted, that charge is a state jail felony. A state jail felony carries a punishment range of not less than 180 days or up to 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand that range of punishment
Yes, sir.
in the plea bargain?
Yes, Your Honor. We are suggesting 3 years for adjudication and probation, along with the $2,500 fine, $500 attorney's fees, and $180 lab restitution fee.
And court costs 1 day in credit and special and regular terms and conditions of probation.
Yes, Your Honor.
Is that your understanding, Mr. Charlton?
Yes, sir.
Is that your understanding, Ms. Fallhaber?
It is.
Mr. Charlton, a few minutes ago, you told me you could read and write the English language. I'm going to show you 2 documents here, the first of which is the agreed plea recommendation. Did you read and go over both the front and the back with Ms. Fallhaber?
Yes, sir.
Did you sign the front and the back?
Yes, sir.
Any questions about it?
Yes, sir.
The next document I'm going to show you is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign the second page?
Yes, sir.
Any questions about it?
No, sir.
Do you have any questions about any of the documents that you read and went over with Ms. Fallhaber?
No, sir.
So if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? Do you want to do this plea bargain? And I'll ask you, sir, how do you plead to that state jail felony offense of possession of a controlled substance as alleged in the indictment? Guilty or not guilty?
Guilty.
And are you pleading guilty because you are and for no other reason?
Yes, sir.
I'll hear the evidence.
We have 3 pieces of evidence to offer. The first is an incident or offense report from the question.
You want to just offer them all three at once? It's quicker that way.
Oh, yes, Your Honor. We also have the case submittal inventory report and a lab report.
And those are 2 and 3 respectively.
Yes.
Any objection? Admitted. Anything else from the state?
No, Your Honor. Rest of those.
Okay. All right, Mr. Charlton, then based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will follow the plea bargain, defer making any finding, places you on 3 years community supervision. You do have 1 day credit as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, lab fee, and abide by all the regular and special terms and conditions of community supervision. Mr. Charlton, have you ever been on probation before?
No.
Well, there's a lot of things a lot of things you have to do and a few things you can't do while on probation. Do you know what can happen to you if you violate this probation? What can happen?
I go to state jail.
For how long?
State jail.
It's actually up to 2 years.
Up to
Do you know how state jail time is served? Generally day for day. You only got 1 day credit too after today. So if you get 2 years, you pretty much do 2 years. Here's what can happen. If you violate even one term or condition of this community supervision, a motion would be filed, a warrant would be issued for your arrest, you'd be brought back before the court. And if at a hearing, the court found that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you to 2 years in state jail. You understand that? I know you told me earlier you were going to meetings. It's extremely important now that you get clean. Talk to your probation officer. They have lots of resources they can refer you to. I'd rather have you out living a productive life than in jail, but I won't hesitate if I ever found that you did violate a term or condition to revoke you and send you to state jail. I don't want to. So get help, okay? All right, sir. Good luck to you. You need to see, well, have a seat, and then probation, you got something for him? Okay, they'll come over and see you. Yes, ma'am. Thank you.
COVID, it's not a flat tire.
Buffet.
I think there's something going right now. That's why I wouldn't do this.
I hope not. I'm on my way to Houston. So is that your only one?
I have 2 others, Judge.
Let's deal with them first and I'll figure it out. Who you got?
Ronnie Gilmore in custody, Judge.
Mr. Gilmore, come on up, sir. Just keep you in the loop. Mr. Gilmore? All right, I'm gonna call your case. This is CR 21-0060-392, the state of Texas versus Ronnie Gilmore, set for pretrial. Any pretrial from the state?
Yes, Your Honor, standard motion.
No objection, Judge.
Granted. And on behalf of Mr. Gilmore,
Judge, I visited with Mr. Strong this afternoon. I need a little more time on pretrial, maybe 30 days. It just give me some time to finish reviewing video and advising Mr. Gilmore how he needs to proceed.
okay, July, I'll just reset it for July 8th for pretrial. Is that all right, William?
What is the date, Judge?
July 8th, 1:30. That would have been the status date, but I'll just reset pretrial.
Thank you, Judge.
Mr. Gilmore, I'm sure you're all right with that. All right, we'll see you on July 8th at 1:30. Howard. Can I see the docket sheet for Mr. Howard? Docket sheet, Mr. Howard. Well, Mr. Howard, this is cause number CR 21-0040-392, the state of Texas versus Jeffrey Howard, set today for pretrial. Any pretrial from the state?
Yes, Your Honor, standard motion.
No objection.
Granted, and on behalf of Mr. Howard.
Judge, I've got that same request on Mr. Howard's case as well.
All right, well then, Mr. Howard, you all right if I reset your pretrial to July the 8th?
Yes, sir.
All right, you're the one on bail. Then by agreement, I'm resetting your pretrial to July the 8th at 1:30. So as soon as you receive your reset notice, you're free to go. I saw you passed your last drug test, so I'm not going to test you today.
Thank you, sir.
Yes, sir. Can I see, while you're up here, can I see Mr. Waters' docket sheet? Let's go off the record for a second. Is it bad? Can he stand right there at the, I'm gonna reset him,
Okay.
but I need to order him to come in and take a drug test sometime. What do I say at the beginning of every docket? You want to wear a mask? Wear a mask. You don't, don't.
Want to check in on the CPS days?
I'm just gonna bring him right there. You're fine.
I think, yeah, I think he had stepped outside the judicial complex, so I think Ronnie knows where he is.
Okay, I'm gonna just, can he zoom in? No, yeah, but I need to order him to take a drug test. I bet he can zoom in. Can you call, hey, Ronnie? Can you call him, Steve? Do you have his
I
number?
don't have it. No, sir.
Can you like tap on the window and say, and is she with him?
That's his mother.
Ma'am, what's going on with Mr. Waters? Yes, ma'am.
He is here, but he has diarrhea and he had an accident.
Get an accident? I got you.
And we need to either go get him some clean.
No, I just, let's just do this. I'm gonna reset his case for July the 8th at 1:30.
July the 8th.
Yes, ma'am. And you're gonna get a copy of a reset notice, but I'm gonna write on there, if we could, Mr. Strawn, that he's to report for a drug test. How about Friday morning? Friday morning at 9 o'clock.
We will be here. And thank you so much.
Well, I understand. We don't want him in here either. This is not COVID related, ladies and gentlemen. Well, it may be, I don't know. I had COVID, but I didn't have that problem. I worked through mine from Zoom. Did you put that on there?
Drug test, Henderson County probation this Friday.
9 o'clock?
Thank you. Thank you. Thank you so much. I appreciate it.
Judge, that's all my business.
You want to go ahead and sit in the car and fill out your
No,
time?
no, no. No, I went through that yesterday, not to that extreme, but that's why I was on Zoom.
Let's see. Mr. Scott,
Jessica Estes.
Miss Estes, come on up. Man, I see her back. This is cause number CR 21-0013-392, the state of Texas versus Jessica Estes. And that is set for pretrial, any pretrial from the state.
Your Honor, we actually have a,
Motion, but I don't know if it-
yeah, no objection to that.
Granted.
Motion. We actually have a PTI agreement and we have a waiver of jury trial for you. My client's already paid the fee, filled out the application.
Did you take a drug test recently?
I don't know. I'm sure she will over at the court today. She brought her.
Has she already taken a drug
medication
test today?
today.
Well, I'm gonna order her to take one, but let me admonish her. All right, and ma'am, I'm gonna place you under oath strictly to ask you some questions about this document and nothing else. So if you could raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So I hope you got it.
Yes, sir.
And lower your hand. I'm gonna show you this form waiver of jury. Did you go over this form with Mr. Scott?
Yes, sir.
Is that your signature there?
Yes, sir.
Do you have any questions about it?
No, sir.
Well, I know that Mr. Scott explained to you that you have a constitutional right under both the US Constitution and the Constitution of this state to a jury trial if you so choose. You understand that?
Yes, sir.
And nobody can take that away from you.
Yes, sir.
And do you want a jury trial?
Yes, sir.
All right, and do you want to waive your right to a jury trial and enter into this agreement you
Yes, sir.
have? Now, do you understand that with whatever this agreement you have with the state, if somehow it falls apart, this is still in effect, this waiver, so you would have a right to a trial, but that trial would not be in front of a jury, it would be in front of the court, you understand that?
Yes, sir.
And you want to continue to,
Well, Your Honor, I mean, the court's comments about a drug test kind of concern me. I don't want the court to have that if you're planning on testing her with the intention of not following through with PTI. I don't want I want to withdraw that document. I don't understand why she would need to be drug tested for, if she's going over to the probation department. That would be a part of,
thought it was already part of the PTI.
I understand, but the way the court presented it, it's like, we're going to see what this test comes out as and then decide what we're going to do today. I don't want.
Are you bringing the bond or the actual, is she gonna give her vote today?
Well, no, the court's comment was that we're gonna, have she been drug tested, we're gonna send her for a drug test.
No, hold on. The
That-
court's comment was she hasn't done the PTI. So as far as I know, y'all have a deal that may or may not go forward. So that's why I'm admonishing her. Hey, I don't know what's going to happen, but you've executed this document. If she fails it, whether I order it or they test her over there and then the PTI falls apart. So does she want a drug test first before I agree to it?
Is that gonna have any effect on the PTI?
I'll have to talk to Ms. Palmer since she.
See, I don't,
Yeah,
that's the
I
thing. I
don't-
don't know how they work their PTI.
Right,
program.
I mean, if that's gonna be the way it is, no, I don't want the court to have that document, we withdraw that document.
See, I can talk to Ms. Palmer.
Hold on now. I think we're all getting wrapped around the axle. They're going to drug test her anyway, right?
I've been involved in a lot of PTIs where they failed the drug test and it was. So.
Well,
if she's
let's
gonna
do
give her-
this.
Any probation, Your Honor, they drug test them, oftentimes we know they test positive on that first one. I don't think that should be a reason to withdraw a PTI offer. I mean,
But it's not my offer. It's theirs.
I know, but saying that you're gonna go send her over for a drug test made it seem to me as if this is separate from, it's just gonna be a normal, you're going probation, they're gonna drug test you like they do everybody else that they leave on probation at first, and everything's gonna be fine. The way you presented it leads me to believe that we're gonna be stuck with a waiver of jury, and then the state's gonna withdraw their PTI. I don't want that. I want to withdraw the waiver of jury.
That's why I handed it back. I
Right.
mean, I'm treating her just like I would anybody else.
Well, but you don't tell, when I come up here with probation plea, you don't tell my clients, well, have you passed your drug test yet? That's not how it works. That never happens.
I'm getting offended, Mr.
I'm
Scott.
sorry, Your
And
Honor.
your tone is kind of offensive. It's that, that's not how I presented it. The thing is, I'm going to treat her like I do anybody else. We have a PTI worked out. I don't know whether you do or not. When it's set for a plea, the plea papers are sitting right over here and they're getting ready to come to me. Y'all could not work it out. So my admonishment to her is, hey, I don't know what's going to happen, but if this don't work out, you're stuck. I'm doing her a favor. So here's what I'm gonna do. I'm gonna recall the case.
Well, Your Honor, I didn't mean to offend the court.
No.
I'm trying to protect my
I
client.
got you, but I'm gonna
Yeah.
recall the case. Who we got next?
Well, where do we go?
Y'all
from
just go
now?
talk about whether y'all want to do it.
I probably wasn't making my point clear, Your Honor. It's
That's
that-
okay. Anybody else ready? All right, here's what I'm going to do. I'm going to call your name. If you hear your name called, just let me know that you're here. Alexander Height. All right, gotcha. Miss Altier is here somewhere, right there. David McKee. All right, have we seen Mr. Mills? I don't see him. Okay. Rico Brown. Gotcha. Yes, sir. June Howe. Michael Halsey. Gotcha. Kelly Jackson. Gotcha. James Kuykendall. Gotcha. Matthew Poe. Gotcha. And Christopher Thompson. Nobody in the waiting room. He's in the wrong waiting room. If he's in the waiting room. Yeah, see, look, there's nobody there. They were not here. What's here? All right, anything else ready? All right. Here, I should take that one back. Is this height that we're doing? Mr. Mills, I think you got some clients, but we're going to do something, Miss Altier, real quick, and I'll get back to you.
Sounds good.
Yes, sir. If it all falls apart, you're gonna be stuck with this. We're trying to protect you. Are we ready? Come on, Mr. Height. All right, this is CR 21-0010-392, the state of Texas versus Alexander Height. And that is set for pretrial today. However, a plea has been presented to the court. Is the state ready? And on behalf of Mr. Height.
Defense is ready, Your Honor.
All right, sir, is your name Alexander Height?
Yes, sir.
And are you the same person that was originally indicted by a Henderson County grand jury for the third-degree felony offense of possession of a controlled substance? I get you to raise your right hand the best you can, sir. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Height, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Height, have you ever been treated for any mental health or emotional issues? I got to ask you. I got to make it. I got to make a ruling on your competency. And do you understand what's going on in here today?
Yes, sir.
And Ms. Altier, do you believe your client is competent?
I do, Your
And
Honor.
the court finds that he is. Mr. Height, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
But do you understand the charge?
Yes, sir.
Well, as originally indicted, that charge is a third-degree felony. A third-degree felony carries a punishment range of not less than 2 years, no more than 10 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
However, it's my understanding you have this deal worked out with the state whereby you'd plead guilty to the lesser included offense, a state jail possession. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
And finally, it's my understanding that they're recommending that the court convict you under a state jail felony offense, but punish you as a Class A misdemeanor. A Class A misdemeanor carries a punishment range of up to 1 year in the county jail and a fine not to exceed $4,000. Do you understand all those ranges of punishment?
Yes, sir.
I have to tell you those too. All right. And the plea bargain?
Thank you, Judge. The agreement is to go on the lesser, as you've already mentioned, on the possession of substance less than 1 gram. The agreement in that is to go under 12.48 days, county jail time, plus
Is that your understanding of the plea bargain?
Yes, sir.
Is that your understanding, Ms. Saltier?
It is, Your Honor.
Well, Mr. Height, a few minutes ago, you told me you could read and write the English language. I'm holding it. I'm going to show you 2 documents. The first is the agreed plea recommendation. Did you read and go over that with Ms. Altier?
Yes, sir.
Both the front and the back?
Yes, sir.
And did you sign it?
Yes, sir.
Any questions about it? The next document I'm referring you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document?
Yes, sir.
And did you sign that second page?
Yes, sir.
Do you have any questions about it? Do you have any questions about any of the documents that you read and went over with Ms. Altier? Well, if you read and went over these with her, I know she explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial in this case? You want to waive your right to a jury trial and enter into this plea bargain with the state? And I'll ask you, sir, how do you plead to the lesser included offense of that which is charged in the indictment, the state jail possession of a controlled substance, punished under 1244A of our penal code? Are you guilty or not guilty? And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I hear the evidence.
Thank you, Judge. State offers states 1, states 2, and states 3. And the other states 1 is the offense report, 2 is Martin discovery compliance, and 3 is our lab report.
No objection, Your Honor.
Admitted.
Further, rest in close.
Rest in close.
Your Honor.
All right, Mr. Height, and based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense under 1244A of our penal code. The court will follow the plea bargain, sentences you to 100 days in the Henderson County Jail with credit for 30 days, and orders you to pay your fine, attorney's fees, court costs, lab fee, including, that lab fee is $180 in restitution. And let's see, Mr. Height, have you had an opportunity to review the judgment of conviction in your case? Was your name, the charge, and the time credit correct? All right, sir, now that you've been finally convicted of this felony offense, you are now under Texas law ineligible to possess a firearm or ammunition. If you have any questions about that, consult with an attorney. You're now remanded back to the custody of the sheriff to serve out the remainder of your sentence. You need to see Mr. Halbert to your right before you sit down, and good luck to you. Yes, sir. Yes, ma'am. Thank you. Mr. Mills.
Yes, sir, Judge. I think I have David McKee on the docket.
David McKee.
I'm still doing.
I try to slow down.
No, you're fine. It's just- he doesn't wait till he finishes his
He's coming, Mr. Mills.
Okay.
I know he's here because we called the roll earlier. Come on up, sir. You can see your attorney right there, and if you stand right there, he can see you, okay?
Okay.
All right, I'm gonna call your case. This is cause number CR 21-0062-392, the state of Texas versus David McKee, set for pretrial. Any pretrial from the state?
Yes, Your Honor, it's a standing motion for discovery.
Granted.
There's no order. Nothing else.
And on behalf of Mr. McKee,
Judge, we have no pretrial motions. I've received a discovery and a plea offer of 15 months state jail from the DA.
all right, then, Mr. McKee, the court deems pretrial is held, and your next court date is July the 8th at 1:30 for status, which is typically your last day to resolve your case by plea bargain or otherwise, or it ends up on the trial docket. Okay, sir? All right, so once you receive your reset notice, you're free to go. Stay in touch with your bondsman and Mr. Mills.
Is that for 1:30, Your Honor?
Yes, sir.
I think that's all I have, Your Honor.
Hold on, did he have another one? Nope, that's it. Appreciate you.
Thank you.
Anything else ready? Okay. Mr. Poe. Oh, this is a plea? Mr. Poe, can you take your hands out of your pocket, please? You make me nervous. Thank you. This said on a motion to show cause. I think you were talking about, sir.
It is, Your Honor. He was just served today. He is entitled to.
I guess because you said it for a hearing. What's the, can I see the motion? It's a motion to limit. Did you file it?
I did not. This one required personal service. We had given service to the attorney. We attempted to find him. It's the house on his.
No, you, okay. Yeah, but I mean, on a bail hearing, I don't have to give notice. I give notice to appear in court if he's in violation of his bail or his conditions. Right. I mean, I don't.
It's done by Zoom.
What does Zoom have to do with it?
We are making a novel argument.
Ooh, a novel one. I gotta hear this.
So I do want that the court to be prepared. State's favorite. Appeal case law hasn't always been in favor of oral orders, and this was done via Zoom. Notice was given. He halfway complied with what was told. He also confirmed it on Zoom. Ordinarily, case law has said that it requires written orders.
So if I told a defendant to go take a drug test and don't go, for example, say they're right here in court, like Mr. Scott's client. So I say, go take a drug test and don't leave until we go over the results together, and I sign it. Well, I'm just giving them an order to take a drug test. I'm not giving them an order to come back in the court. You're saying that's
I
not
think
a,
it would be part of the written in that case.
but would it?
The case law goes back to 67 before the act.
But I don't think Zoom would have. Let's go off the record because we're not, because I'm not gonna do anything today, but. I mean, you're looking at it as contempt because he violated the court order. I'm looking at it as violation of bond.
Did he have one condition?
No, I don't know anything about it. All I know is get a show cause.
No, I don't think you did.
If you have blind conditions, he's sworn to apply.
Okay. But I know you can do direct contempt. The court orders you to do something and you don't do it.
Usually that's in court.
Right. but this is Zoom.
I don't have any case law in Zoom.
Crazy, isn't it?
I feel like you would be entitled to that,
No, I love novel stuff because, you know, it's out of the old boring rote stuff.
but I can't promise that I need to tell the court.
Okay.
The case law is not on my side.
Since you just got served today, I mean, you would ask for 15 days.
May I see the docket sheet? This Monday? 2:30? That's not 10 days.
I wouldn't be available, maybe you would be.
Just do July 8th, 1:30. However, based upon the nature of your charges, Mr. Poe, I'm ordering you to take a drug test today. You're going to go take the drug test, and when you get done, you're going to come back in the courtroom and go over the results together. Do not leave. We're going to go over the results together when you get done taking it. I'm going to order him to take a drug test today. Yes, sir.
The next one, Your Honor, is arraignment and a plea is on Christopher Thompson. And he is present in hall.
It's an easy way.
Sir,
Well, I think there's another argument about whether, since it's contempt, since they're moving under contempt, you do have to give him notice, since the state's moving. I'm sorry, who are we doing?
it's going to be an arraignment and a plea, Christopher Thompson, he is present.
Mr. Thompson, come on up, sir. Hold on a second. You might want to talk to your lawyer before you say something. Do you need to talk to her real quick? Ms. Thompson, if you can step out there. Don't step on the rail. We're in front of the rail. We've got another hearing. Go ahead and give me the paperwork on this one. Is there a full moon out? I'm gonna sign your paperwork, Mr. Thompson, while she's talking, so just give me a second. We good?
I don't know, yeah.
Well, let's move on to this plea. That's it's an arraignment too?
It's arraignment first here because he has not been arraigned in that, in a plea.
I got it set for pretrial.
I thought it was arraignment.
I got the.
You know what, you're right, yeah, absolutely, yeah, I do remember, I thought about this yesterday. And
Can I
got
see the
mixed up.
docket sheet?
It is pretrial. That's a plea. Yeah, it
There
is.
was a waiver of arraignment filed.
Yes, that's it.
Okay, gotcha. All right, are we all ready then?
We're ready, yeah.
All right, this is CR 20-0641-392, the state of Texas versus Christopher Lamont Thompson. Set for pretrial today. However, a plea has been presented to the court. Is the state ready?
Yes, Your Honor.
And on behalf of Mr. Thompson,
We're ready, Your Honor.
all right, sir, is your name Christopher Lamont Thompson Jr.? And are you the same person that was originally indicted by a Henderson County grand jury for the state jail felony offense of possession of a controlled substance? All right, I can get you to raise your right hand, sir. Do you solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God? You can lower your hand. Mr. Thompson, can you read and write the English language? Are you a U.S. citizen? If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that? And Mr. Thompson, have you ever been treated for any mental health or emotional issues? Do you understand what's going on in here today? Ms. Thompson, do you believe your client is competent?
He is.
Court finds that he is then. Mr. Thompson, it looks like there was a waiver of arraignment filed in your case. However, have you reviewed the indictment in your case?
Yes, sir.
And do you understand what you're charged with? And do you need the prosecutor to read it out loud in the courtroom? Well, that indictment charges you with a state jail felony. A state jail felony carries a punishment range of not less than 180 days or more than 2 years in a state jail felony facility and a fine not to exceed $10,000. Do you understand that range of punishment in the plea bargain?
The state is recommending 2 years deferred adjudication of probation, $400 fine, $500 attorney's fees, $265 court costs, $180 restitution, as well as the standard and special terms and conditions.
Is that your understanding of the plea bargain, Mr. Thompson? Is that your understanding, Ms. Thompson?
It is, Your Honor.
Well, Mr. Thompson, a few minutes ago, you told me you could read and write the English language. I'm going to go over two documents with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back of that document? And did you sign it? The next document I'm going to refer you to is the court's admonishments and warnings prior to entering a guilty or no contest plea. Did you read and go over both pages of that document? And did you sign the second page? Do you have any questions about it? Do you have any questions about any of the documents you read and went over? Well, if you read and went over these with Ms. Thompson, I know she explained to you that you have many constitutional rights, including the right to trial by jury. You want a jury trial. You want to enter into this plea bargain. And I'll ask you, sir, how do you plead to that state jail felony offense as alleged in the indictment? Guilty or not guilty? And are you pleading guilty because you are guilty and for no other reason? I hear the evidence.
We have 3 pieces of evidence to offer up. The first is the police report from the day in question. The second is the district attorney's initial case submittal inventory report, and the third is the lab report.
There's no objection to all three.
All right, 1 through 3 are admitted. Anything else from the state?
No, the rest of it.
And Ms. Thompson?
Rest of them.
All right, then, Mr. Thompson, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty. However, the court will follow the plea bargain, defer making any finding, places you on 2 years community supervision with credit for 7 days as to any sentence you may eventually have to serve, and orders you to pay your fine, attorney's fees, court costs, and lab fee, and abide by all the regular and special terms and conditions of community supervision. Mr. Thompson, have you ever been on probation before?
No, sir.
All right, well, there's a lot of things you have to do and a few things you can't do on there. Do you understand that? You know what can happen to you if you violate any term or condition? What can happen? For how long? However long? Well, up to 2 years. And do you know how state jail time is served? Typically day for day. So if you get 2 years, you do 2 years, and you only have 7 days credit. All right, so here's what can happen. If you violate even one term or condition of this community supervision, a motion could be filed, a warrant would be issued for your arrest, you'd be brought back before the court. If at a hearing, the court found that you violated even one term or condition, the court could find you guilty, revoke your probation, and sentence you up to 2 years, you understand? So would you agree with me? It's extremely important you abide by these. I hope you do, sir. Good luck to you. You need to see probation before you leave.
Well, I can come back for the drug results list because I have a CPS case.
I got you. We'll call you. Hey, Valley. You gotta say.
Yeah, some kind of Christian.
Mr. Stevens.
Judge, we are ready, or if we may approach real quickly off the record.
Hold on, I'm still on YouTube. It's all right. Michael Holsey. All right, these are cause numbers CR 20-0678 and 0679-392, both styled the state of Texas versus Michael Holsey, and both set for discovery status.
Your Honor, I did look on the discovery day. It does appear I've received everything. I don't think there's been an offer made yet, but other than that, I think we've received all the discovery.
That is correct, Your Honor. We have an appointment with a victim, and so we'll get an offer tendered.
Okay. All right, so nothing outstanding that you know of?
No, Your Honor.
All right, well then, Mr. Holsey, the court deems discovery status is held. Your next court date is July 7th at 9 a.m. for pretrial. So stay in touch with your attorney and your bondsman, and we'll see you in July on the 7th at 9 a.m.
Thank you, sir.
Yes, sir. As soon as you receive your reset notice, you can go.
And we're ready on James Kuykendall.
James Kuykendall. Alrighty, these are cause numbers CR 21-0045, 0046, and 0047-392. All three style the state of Texas versus James Kuykendall, and all set for pretrial. Any pretrial from the state?
Yes, Your Honor. See your motion.
Granted. And on behalf of Mr. Kuykendall.
No, Your Honor, no contested pretrial.
All right, then, Mr. Kuykendall, the court deems pretrial is held in each of these cases. Your next court date is on July 8th at 1:30 for status, which is your last day typically to resolve your case before it ends up on a trial docket. And does he have an offer?
There's a 10-year offer, Your Honor, to run concurrent.
Take care of all three of them?
Yes,
Okay.
sir.
All right, Mr. Kuykendall, we'll see if you get out of jail between now and then. I need to see you back on July 8th at 1:30. Thank you, sir.
My two are going to be pleased, Your Honor. We're working on the paperwork.
Okay. Yes, sir. Anything else? All right, we'll go ahead and take, Mr. Scott, are you ready on? Is it gonna be a minute? That's all right. I'll take a break. Y'all let me know when y'all are ready.
Send something to the jail? I have.
Where's his car? Oh, here's some. You know,
On open announcements on the 1:30 docket, Mr. Scott. Ms. Estes, come on up. All right, let's go back on the record and cause number CR 21-0013-392, the state of Texas versus Jessica Estes. And Ms. Estes, just for your information, we had an opportunity to talk in chambers during the break to figure out kind of what's going on. And I think we're all on the same sheet of music now. And so I hope you know, both your attorney and I were both trying to protect your constitutional rights. We just had a misunderstanding about what was going on. So what are we doing here?
Waiver of jury.
Okay.
I'm handing you a pretrial intervention application that the state has accepted her into this program.
Okay, that's what I needed. All right. All right, well, first of all, I'm going to go over this first. Ms. Estes, did you have an opportunity to review this PTI contract with Mr. Scott?
Yes, sir.
And you have any questions about it?
Yes, sir.
All right, and so you understand what it is with this contract that you're getting into with the state?
Yes, sir.
All right, I'm gonna hand that back to you. All right, and then next, I'm going to get back on this waiver of jury. You understand, and I kind of got into this earlier, but the Constitution of both the United States and the state of Texas guarantee you a right to trial by jury.
Yes, sir.
And nobody can take that away from you. Do you understand that?
Yes, sir.
And as a matter of fact, it's my understanding that you are only executing this waiver because you're entering into this PTI contract. And I want you to understand that if for some reason something happens during your performance of that contract that causes the state to assert that you're in breach of that contract, you could be required to continue. See if I can put this correct. You could still be required to answer for this felony charge. You understand that? And if I accept this waiver, you would still have a right to a trial, but it just wouldn't be a jury trial. Do you understand that?
Yes, sir.
And you want to continue on with this?
Yes, sir.
And Mr. Scott, do you believe she's executed this waiver freely, intelligently, and voluntarily?
I do, Your Honor.
All right, well, then the court finds that the state has consented, and I am approving this second day of June, 2021.
Yes, sir.
All right, good luck to you, man.
Thank you.
Your Honor.
Want her to go right next door.
Mr. Brown,
Rico Brown. Your
Rico
Honor.
Brown, come on up, sir.
And this is a plea. There's
Brown, I didn't recognize you when you were in court a couple months ago. Been a while, hasn't it?
Yes, sir.
All righty. This cause number CR 21-0056-392, the state of Texas versus Rico Brown. And Mr. Brown is set for pretrial today. However, a plea has been presented to the court. Is the state ready?
Yes, sir, the state is ready.
And on behalf of Mr. Brown,
We're ready, Your Honor.
all right, sir, is your name Rico Antonio Brown?
Yes, sir.
And were you the same person that was originally indicted by a Henderson County grand jury for this third-degree felony offense of assault family violence?
Yes, sir.
I'll get you to raise your right hand. You solemnly swear or affirm the testimony you're about to give now on trial will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You can lower your hand. Mr. Brown, can you read and write the English language?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
If it turns out you're not, and you enter into this plea bargain with the state, it could have certain negative immigration consequences. Do you understand that?
Yes, sir.
And Mr. Brown, have you ever been treated for any mental health or emotional issues?
Yes, sir.
And what would those be?
Bipolar schizophrenia and ADHD,
Are you on medication for that?
but I haven't been taken due to me being incarcerated.
They're not giving it to you?
Well, I gotta pay for it.
Okay, well, do you understand what's going on in here today?
Yes, sir.
No issues with anything that Mr. Scott told you that you don't think you could understand?
No, sir.
In other words, you understood everything he told you?
Yes, sir.
All right, and Mr. Scott, how long have you represented Mr. Brown?
Your Honor, I got appointed to replace James Mills on May the 5th. So I've represented him since then.
It's about a month.
Yes,
And do
sir.
you believe he's competent?
I do, Your Honor.
All right, well, Mr. Brown, even though you've told me you've been diagnosed with these things and you're not taking your medication, I've had you in court a few times The law presumes that you're competent, and based upon your demeanor, your answers to my questions, and the statements of your attorney, I have no reason to find that you're not competent, therefore I'm finding you competent.
Yes, sir.
Mr. Brown, I know that we've already arraigned you on this case. However, would you like the prosecutor to read the indictment out loud here in the courtroom?
No, sir.
You understand the charge?
Yes, sir.
Well, as originally indicted, that charge is a third-degree felony with the enhancement. A third-degree felony carries a punishment range of not less than 2 years or more than 10 years in the Texas Department of Criminal Justice and a fine not to exceed $10,000. Do you understand the range of punishment?
Yes, sir.
So y'all originally indicted this as a third because your enhancements included in the underlying offense. And then you enhanced with a secondary enhancements would have made this a second.
That's true, Your Honor. We're dropping the enhancement and we're pleading to a true lesser included assault, family violence, Class A misdemeanor.
Okay, and did you file a?
Yes, Your Honor.
Okay, I guess I didn't see it on the plea papers. And actually, let me go back. If you were to go to trial on this, Mr. Brown, and the state were to prove beyond a reasonable doubt your guilt, it would be a third-degree felony. And then if they at punishment were to prove this enhancement paragraph true, then the punishment range would be that of a second-degree felony, which carries a punishment range of not less than 2 years, no more than 20 years in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. You understand that range of punishment?
Yes, sir.
I got one more to go over with you. It's my understanding that they're willing to abandon that enhancement paragraph and allow you in exchange for your guilty plea to plead guilty to a lesser included offense of that which isn't charged, a Class A misdemeanor assault, family violence.
Yes, sir.
A Class A misdemeanor carries a punishment range of not more than 1 year in the county jail and a fine not to exceed $4,000. You understand all those ranges?
Yes, sir.
All right, and the plea bargain?
Yes, Your Honor. In exchange for a plea of guilty, the state's recommendation in the plea agreement with the defense is to abandon the enhancement paragraph, reduce it to a lesser included Class A misdemeanor of assault, family violence, 295 days in the county jail with time credit of 295 days as of today, and to agree to a protective order with the victim, Brittany Thompson, which is CD 21-0258-CC2, which he has already signed, Your Honor.
Okay, and just for the record, I wrote her last name on there because only her first name was written.
Thank you, Your Honor.
After you told me her name, and is she on board with the plea bargain?
She is, Your Honor.
Okay. Mr. Brown, is that your understanding?
Yes, sir.
And Mr. Scott?
It is, Your Honor.
All right, well, Mr. Brown, a few minutes ago, you told me you could read and write the English language. I've got 2 documents I'm going to go over with you. The first is the agreed plea recommendation. Did you read and go over both the front and the back with Mr. Scott?
Yes, sir.
Did you sign them both?
Yes, sir.
Any questions about it?
No, sir.
The next document I'm showing you is the court's admonishments and warnings prior to entering a guilty or no contest plea.
Yes, sir.
Did you read and go over both pages of that document?
Yes, sir.
And did you sign the second page?
Yes, sir.
Any questions?
No, sir.
Do you have any questions about any of the documents that you signed?
No, sir.
If you read and went over these with Mr. Scott, I know he explained to you that you have many constitutional rights, including the right to trial by jury. Do you want a jury trial? You want to do this plea bargain?
Yes, sir.
And I'll ask you, sir, how do you plead to that lesser included offense of that which is charged in the indictment, the Class A misdemeanor assault, family violence? Guilty or not guilty?
Yes, guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I hear the evidence.
Your Honor, the state office states Exhibit 1, the offense report, states Exhibit 2, the discovery inventory report.
No objection, Your Honor.
Admitted.
State rests and closes.
Mr. Scott?
Defendant rests, Your Honor, and closes.
All right, Mr. Brown, based upon your guilty plea and the evidence, the court has enough evidence to find you guilty and does find you guilty of that lesser included offense, the Class A misdemeanor assault, family violence. Court will follow the plea bargain, sentences you to 295 days in the Henderson County Jail with credit for 295, finds that the victim is on board with the plea bargain, and orders you to pay your attorney's fees and court costs, as well as not have any contact with Brittany Thompson. And the special terms of the plea agreement were that you agreed to a protective order which you had previously signed.
Yes, sir.
And so before you go, Mr. Brown, did you have an opportunity to review the judgment?
Yes, sir.
Was your name, the charge, and the time credit correct?
Yes, sir.
All right, sir. Good luck to you. You need to see Mr. Halbert to be printed.
Yes, sir.
Can I give that?
Yes, sir. Now, you want to give me the other bill since she signed the contract now?
Sure. I'll have to fill one out. for the one
Yeah,
I did
just submit it.
yesterday.
And I'll just make sure the clerks know that once she
Okay.
signs the contract, to me, it's a done deal.
Okay. I wasn't sure about that. Thank you. I'll get those to you. Have a good one.
You too. Something else going on. I forgot to unmute. We ready?
Yes, sir.
All right. We got a drug test result.
I'm not sure if those have come back. We're gonna go ahead and do the procedural side of things. We're doing a jury waiver. We have an agreement for her to do 40 days in county jail. And instead of doing the plea and having her report, we're gonna
Oh,
come back
yes.
and
I wish I'd have remembered that part. We were taking a drug test.
we'll do the plea, and she understands she's gonna go into custody as soon as we do the plea agreement at the next court date.
Okay, well, come on up, Ms. Howell. It's cause number CR 21-0050-392, the state of Texas versus June Howell. Ms. Howell, I'm holding in my hand a waiver of jury, and so we don't get into the mess we did the last time. I know that I just ordered you to take a drug test. However, I know you've got this plea agreement already worked out, and so regardless of how that test turns out, unless the state pulls the plea bargain,
We'll honor this. plea.
then I will continue on. So, Ms. Howell, I need to put you under oath just to ask you about this waiver here. So if you could raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God. You can lower your hand. Ms. Howell, I'm showing you this waiver of jury form. Does that look familiar to you?
Yes, sir.
And did you read and go over this with Mr. Stevens?
Yes, sir.
And did he explain everything to you?
Yes, sir.
All right, now, I know he did, but I have to explain a few things to you as well. Ma'am, do you know that under the United States Constitution and the Texas Constitution, you are guaranteed the right to trial by jury on a felony offense? And nobody can take that away from you. Do you understand that? The state can't take it away, your attorney can't take it away, and I can't take it away. You are the only person that can waive it. Do you understand that? And even if you do waive it, the state has to consent to it, and then I have to approve it. Do you understand that? All right, and so, right, you're all negative anyway. And so for some reason between now and when are we resetting her? July 8th? Is that fine?
Yes, sir.
All right, so if for some reason between now and July 8th, this agreement that you have falls apart with the state, in other words, you get arrested on a new offense or decide that you don't want to do this plea bargain, you're going to be stuck with this. You understand that? In other words, you will not have a right to trial by jury. You'd still have a right to have a trial, but that trial would be in front of the court instead of a jury. Do you understand that?
Yes.
And do you want to continue to enter into this waiver?
Yes, sir.
All right, and then the court, well, I'll ask you, Mr. Stevens, do you believe she's entered into this waiver knowingly, intelligently, and voluntarily?
I do, Your Honor.
And the court finds that she has, finds that the state has consented, and the court has approved it. This is the second day of June, 2021. And ma'am, you're going to receive a reset notice for your plea on July 8th at 1:30. So we'll see you on that day. Free to go. Yes, sir. Thank you.